Hello, everybody. It's Jessie, Lovelady. You're listening to The Home Show here on News Talk 870 KRLA, the show that has something for everyone. And I'll tell you, I've got a great show planned out for you. Again, if you're planning for your future and you haven't been thinking about it, well, maybe you should, because I have an estate planning attorney here, and he is a certified specialist. And he's going to talk a little bit about everything. So I want you to get ready, get your pens together, because we also have a phone number for you. And here we go. His name is Attorney Forrest Wolfe, and his direct number is area code 909-391-3322. That's area code 909-391-3322. And basically, what I want to do, Forrest, is welcome you to the broadcast. How are you doing?
I'm doing great. Thank you, Jessie.
Great. I'm so proud to have you. You brought your beautiful wife here as well. And I have to say, it's such a pleasure to see you back in studio. Now, my thing is there's a lot of people out there that really don't know the difference between a will and a living trust. So I bet you're going to tell us.
I can do that.
Okay.
Basically, the primary purpose of both is to determine who's going to get your assets, who's going to get your estate when you do pass away, and also to allow you to name somebody to take care of things and make sure that your wishes are followed. The primary difference, though, between a will and a living trust is with a will you go through probate, with a living trust ordinarily you don't.
Ooh, that's good to know. And you don't want to really be leaving things untaken care of, because the state can do that for you, right?
Well, that's true. I mean, if you
don't want that.
Most people don't want that. The state has enough of their own problems. But really, if you don't have a will or a living trust and state what your wishes are, a lot of people think that your property is going to go to the state. And actually, that's not the case. As long as you have some relative somewhere that's alive, the state's not going to get your property.
Oh.
The state statute basically creates a will for you. They assume what people would want to have happen with their estates if they didn't do a will. But again, that may not be who you want your property to go to. So it's much better if you state your own wishes in a living trust or a will.
Oh, sure, because again, those are your wishes, and I think it would make us all feel comfortable that it went to somebody that we wanted it to go to. Now, what is probate? Because that's kind of a word that I've never really understood. So you're educating me too. So tell our listeners what a probate is.
Well, basically, a probate is a court process, and during that court process, they allow you to prove the will, if there is a will, and also make sure that all the creditors of the decedent get paid, and that ultimately the beneficiaries get the property they're entitled to. If you don't have a will, you go through the same process. It's called administration instead of probate, but really it's the same process. It's just you haven't been able to basically state what your wishes are regarding who's going to get your property or who's going to handle it for you, who's going to be your personal representative.
Sure. Now, listeners, if you just tuned in, we are speaking to Attorney Forrest Wolfe, and his direct phone number is area code 909-391-3322. Again, his direct number is 909-391-3322, and you are going to be educated. This is so important for us to hear what he has to say. A lot of you out there are probably asking yourself, maybe I'm too young to think this way, but you're never too young because you never know. Now, why would I've heard that you should, people say that they should avoid probate. What is about that?
Well, there's a number of reasons that you'd like to avoid probate once you know about them. The primary reasons to avoid probate is, one, it takes a long time. In California, well, it's going to be a minimum of 6 months, just because there's a 4-month creditor claim period. You have to schedule hearings with the court. The court's very congested. But really, right now, the average probate in California is running anywhere from 18 months to 2 years.
Wow.
So it can really take a long time, and that's just, without any problems like will contests and that type of thing. But in addition to the time, it's also very expensive to go through probate. The attorney's fees are very expensive. Basically, it's a percentage of the estate that goes through probate, and it's a statutory kind of a sliding scale. The first $100,000 of assets that go through probate, the attorney's fees are $4,000, plus 3% of the next $100,000, plus 2% of the next $800,000, and so on. So it doesn't take a lot of property going through probate to create quite a legal bill. For example, if the only thing you have going through probate, say you've got a house that's worth $400,000, it doesn't matter if you've got a $300,000 mortgage on it. Again, the attorney's fees are all going to be based upon the gross value of the property going through probate. So on a $400,000 house, regardless of the mortgage, you're talking about attorney's fees of around $11,000. In addition, the executor usually is entitled to the same amount the attorney gets. So another $11,000. There's publication fees, there's appraisal fees, there's filing fees of about another $3,000. So to get that $400,000 house through probate, you're talking about minimum fees of about $25,000.
Whoa. Now, do all assets need to go through probate if someone does not have a trust?
Not all assets.
Okay.
There are a number of, most assets have to. But if you have a beneficiary designation, say you've got a retirement plan or you've got life insurance, as long as you've named a beneficiary and that beneficiary survives you, ordinarily those things don't go through probate. For instance, unfortunately, I do see a lot of times that people name their estate as the beneficiary, say in a retirement plan. And by naming your estate, you've automatically put it in probate. Again, you want to make sure that you've got those beneficiary forms filled out and you've named beneficiaries.
Actually put the first, middle, or last name and cross your T's and dot your I. Now, listeners, you are listening to the voice of Attorney Forrest Wolfe. And, of course, he talks about estate planning. He is a certified specialist, so I got somebody very good here. And he works on estate planning again, trust and probate law. And also, I want listeners to know if you have any questions that you would like to address to our attorney, not a problem. Just pick up the phone and give him a call, and he can either make an appointment with you or talk to you over the phone directly. The number is area code 909-391-3322. That's area code 909-391-3322. And also, just to remind you, I'm going to have information at the Home and Garden Show while we're appearing there, August 26th to the 7th and 28th at the Anaheim Convention Center. So if you'd like to come by and pick up a brochure of his or business card, come on by and have some fun with this as well. Now, we asked you about the assets needing to go through probate. This is all very interesting, but I have one question that I think is really a good one. Why not just put your child's name on your property deed? Whoa.
That's a good question.
Okay.
And unfortunately, a lot of people do make that mistake. They've heard that if you have, say, a joint tenancy deed, then if one person passes away, the survivor automatically is entitled to that property. So a lot of times they'll say, well, I want to avoid probate, so I don't want to leave this to my family in a will. And maybe I don't think I need to have a trust, so I will just put my, maybe I've got 3 children, so I'll put one of them on the deed, and I know if I pass away, it'll automatically go to that child, and then they can sell it and divide up the money. Well, several problems with that. Even if you have the best intentions and your child you put on there has the best intentions, most you've created a moral obligation for that child to sell it and transfer the proceeds to his brothers and sisters. But more importantly, a lot of things can happen during your lifetime after you've already put that child on your deed. One, you might change your mind. If you want to take them off, they have to actually sign to be taken off.
Oh, wow.
But more importantly, that can create liabilities for you. I mean, if your child has creditor problems, or maybe they get in an accident on the freeway and get sued,
something?
Suddenly your house is at risk, even though you've only done this to avoid probate. But to all the world, your child is an owner of that property.
I've got to tell you, there's probably people that are listening to this out there right now that is either going to do that or they've done it, and they're just going, what? This is why it's so important to have somebody like you, our attorney, that knows your stuff, because I never thought that. I never thought about something like. Now, what about joint tenancy with a husband and wife? Is that different?
Joint tenancy with a husband and wife, and that's how most married couples, if they don't have a living trust, hold their property. And that's fine. Sometimes they think, well, we'll just hold it as joint tenants. We know if one of us passes away, it goes to the survivor, and then at that time, the survivor can make a trust to pass it on down to the family.
I see.
But unfortunately, a lot of times, well, maybe not a lot of times, but sometimes something happens to the two of them together in an accident. Or by the time one passes away, the other person does not have the competency
to make the decision,
to do the trust. And sometimes what will happen is on their deathbed, they might do a quitclaim deed to one of their kids, not realizing the tax implications. Because federally, we have what's called a step-up in income tax basis. If you die owning your property, basically your beneficiaries get a step-up income tax basis. So if you paid $50,000 for the property and it's worth $500,000 when you pass away, as long as you owned it when you pass away, your beneficiaries now have a $500,000 tax basis. So they could sell it the next day, or 2 years later after probate, they can sell the property and not have any taxable gain. Whereas if you make a gift to your family or to anybody during your lifetime, they end up with your income tax basis in the property. So same thing, if you paid $50,000 for it, but you gift it on your deathbed to your beneficiaries with a deed, they have your $50,000 basis. They sell it after you pass away. They've got a $450,000 capital gain they're going to have to pay tax on. Whereas if they just had a living trust, it would have passed upon the person's death, and there would be no taxable gain, no probate. It's all very easy just by waiting.
Ladies and gentlemen, get an attorney. Do a living trust. I'm hearing words here, statements that are made here that is very important to all of us. And again, let me give you the direct number for our attorney. Attorney Forrest Wolfe is at area code 909-391-3322. That's area code 909-391-3322. And I want you to stop because we're not done yet. We'll be back in a moment right after this.